case briefs, and so much more. LSData's got what you're looking for.
The U.S. Court of Appeals for the Fifth Circuit heard a case in 1988, Tanglewood East Homeowners v. Charles Thomas, Inc., centered around property owners' liability for cleanup costs and injunctive relief under environmental laws, even if they did not cause the contamination. The property owners in Montgomery County, Texas, sued residential developers, construction companies, and real estate agents and agencies involved in the development of a subdivision built on a highly toxic waste site. The Environmental Protection Agency included the site in its national priorities list for cleaning under the CERCLA and RCRA. The property owners sought damages, response and cleaning costs, and injunctive relief under both acts. The defendants filed a joint motion to dismiss, which the district court denied, and the defendants then appealed under 28 U.S.C. Section 1292(b). The court affirmed the denial, finding no error. The district court's judgment was upheld because RCRA's equitable relief provision addressed past and present violations, allowing injunctive relief for both.
Case briefs, and so much more. LSData's got what you're looking for. Visit LSD.law, elevate your mind. Leave the stress of class.